Well, thank you. As was mentioned, my name is Marco Quesada. Welcome to CPS 201, Understanding the DFPS System. Just to give you a little bit about myself, I've been with the agency for about 14 years, the last 8 of which I've been here at State Office as the Substance Use Program Specialist. I'm currently the Substance Use Program Specialist lead for CPI, Child Protective Investigations, but I do have a background in the field in all 3 stages of service. I did some time as a conservatorship worker and supervisor and family-based and investigations as well. So I'm familiar with all stages of service and have a passion about helping families with substance use disorders. My parents, I myself am a child of parents with substance use disorders. So this topic and this work is very, very personal to me. And I take it seriously, and I take advocating for these families very seriously. As the title indicates, this is CPS 201. I had the pleasure of co-hosting CPS 101 last year for this conference. However, you guys do not need to have participated in 101 to gain something from 201. Last year's presentation was a really broad basics about when you call in an intake, what happens to it. So it kind of followed the path of from intake to the end, how it works. This year's presentation is going to really focus more specifically on the different stages of service and what that means to you all working with these families. We're gonna address some terminology issues, and we're gonna figure out how to advocate for families. There we go. So here's the objectives. Again, I just mentioned we're going to overview the different stages within DFPS, redefine common terminology that's often misunderstood, and then advocate, figure out ways that we can actually, advocate for families. So when we talk about stages of service, when we use that term stages of service, we mean within DFPS, we have different programs, and those different programs do actual different things. So I know in the community at large, when you have parents talking about CPS, they're generally just saying CPS. And even when we're talking to community providers or stakeholders, whether it's hospital systems, treatment providers, et cetera, again, even in those settings, you just hear the term CPS. But actually within CPS, we have subcategories, we have stages, and then those stages have different responsibilities. So in the investigation stage, which includes investigations and alternative response, in those stages of service, those individuals are doing investigations and assessments. That means that they're getting an intake with an allegation of abuse or neglect, and they're determining whether or not that actually occurred, or if abuse or neglect occurred due to what was alleged. So as an example, that might be something as simple as there's an allegation of neglect because there was, I don't know, a 6-year-old wandering around the street unsupervised for 45 minutes, and they're concerned that the parent had no idea where they were. An investigator may go out there and investigate that situation and determine if that truly was the case, if this child, was truly unsupervised, or if there was somebody out there watching them and the reporter maybe just didn't see an older sibling kind of keeping an eye on them, et cetera, et cetera. So those allegations are investigated in the investigation stage. Alternative response is just a subset of investigations where those cases are not dispositioned. There are specific criteria that are required for it to qualify as an alternative response case. Generally speaking, alternative response cases are somewhat lower risk. They're a little bit higher age children. But in those cases that are deemed to qualify for alternative response and are assigned to an alternative response worker, they're handled a little bit differently. There's no disposition that comes out of it. So there's not an affirmation, if you will, of yes, abuse and neglect did or did not occur. It's just simply an assessment. In the traditional investigation, those tend to be either younger, more vulnerable children or higher risk allegations. So those would be things like, you know, substance use, domestic violence, things of that nature. Those might go through a traditional investigation phase. And again, the worker assigned the case would simply go out, meet with the family, address the allegations. They would interview the child or the children in the home, get their perspective, and then they would interview collaterals. They might interview professionals, neighbors, et cetera, et cetera. Family-based safety services is a more intensive stage, but at the same time least restrictive. So in CPS, we do not have social workers in the traditional sense. So we certainly employ individuals with social work degrees for sure, but what's required of them is not specifically to do social work. However, I think we could all agree that family-based safety services is the most social work-like stage of service within DFPS. Those cases that are assigned to family-based safety services are cases in which they're voluntary, first of all, and those cases involve a caseworker who's working collaboratively with the family for a relatively short period of time, typically between 3 to 6 months. There's some outliers there, but generally for 3 to 6 months. And they're working with the family to engage them in services. And then lastly, the most involved stage of service and the most, I guess, difficult, or certainly difficult for the family and most restrictive by far, is conservatorship. Conservatorship that means the department took temporary managing custody of the child, and there's a clearly defined timeline where the allegations of the abuse and neglect need to have been formally addressed and mitigated by a very specified date, and those dates are all outlined in Texas Family Code. So there's a year deadline. There's some exceptions to that, and we'll get into that in a minute. But when you hear the term conservatorship, you're talking about cases where we have temporary legal custody. So how the stage is different. They're different in a number of ways. They're different in one's just how long the stage is open. So again, going back to investigations, when we're talking about investigations or alternative response, the expectation is that that assessment be wrapped up, completed, and whatever needs to have happened has happened within 45 days. Doesn't always work out that way for a variety of reasons, but that's the expectation. The expectation is that within 45 days, and honestly, hopefully sooner than that, it gets identified, and either the investigation case is closed, or we determine that the family would benefit from some level of support, and the case is what's called stage progress, meaning that it goes from investigations to family-based safety services, or it goes from investigations to conservatorship at some point within that 45 days. Again, family-based safety services is different and unique in that it's a collaborative. It is largely voluntary. There are very, very few exceptions. There are times where there are court-ordered family-based safety services cases, but that's kind of the exception, not the rule. Most of the time, 99% of the time, family-based safety services cases are in fact voluntary, meaning that investigations has gone out, assessed the family, determined that the family could benefit from some resources. The family has agreed that they would benefit from those resources, but they need kind of a caseworker or a case manager, if you will, kind of in the interim to help connect them to those resources. At that point, a family-based safety services worker would be assigned and make those connections monitor, for that 3 to 6 month period, make sure that the family is engaged in whatever services might be appropriate. That could be therapeutic, that could be substance use treatment, that might be domestic violence related, that may be a combination of several types of services. But those things, again, would occur, and within 3 to 6 months, generally speaking, those assessments are done, and the case is submitted for closure. We do have some outliers. We do have some cases that extend out 8 or 9 months if the parent, for example, has been on a waiting list for a provider and they were unable to get engaged early on in the case, or if there was, maybe a lack of progress. There's also, family-based safety services cases that resolve sooner than 3 months. There are times it gets resolved in a month because we're able to make that connection, and that the provider has the ability to do wraparound services, and they're going to be very involved and monitoring the family. And so there's no need for us to kind of duplicate services. So we do see some outliers on either end, but generally speaking, we can expect those cases from the DFPS perspective to be open for, again, 3 to 6 months. And then, as I mentioned a moment ago, conservatorship cases, lastly, are our most intensive cases. There is a formal court involvement, so there is legal documentation. There's an affidavit that's been filed, that's been read and approved by a judge. We have been granted temporary custody. And what that means in the state of Texas, by the virtue of Texas Family Code, is that we have 1 year from the date that TMC was granted, temporary managing conservatorship was granted, to resolve the issues that brought the family into the conservatorship of the department. It can certainly close sooner than a year, so we don't have to wait a year to close that case, but we have 1 year. Now, Texas Family Code, again, it does allow for a one-time 6-month extension for kind of, outlying circumstances, so that it's not automatically granted. The idea is not that we're just going to hold the family for 18 months. That's not the intent, but there are situations in which it might become necessary. As we approach that 1-year deadline, something may happen that might require us to keep the case open longer than originally expected. So some examples of that might be something like, a relapse at month 11 as we're getting ready to close the case. Something completely unforeseen happens. The parent caregiver relapses, and the shift of the case suddenly changes from figuring out how to transition the kids back to the home to suddenly, okay, well, what services and supports can be put in place to address this caregiver's relapse? Can we get this parent back into treatment? Can we get this parent into some aftercare provider? Is there a therapeutic piece that maybe wasn't adequately addressed that ultimately led to this relapse? So everybody's kind of working on that end to try to address that, so that we can get that piece resolved, so that we can be back in a good place within that 6 months time frame to return those kids home. Again, the goal is always to reunify. We might have a concurrent goal, which means we have a backup plan along with our primary plan, but the primary plan 99.9% of the time is family reunification, with a concurrent plan most often, in most cases, being relative adoption, meaning that if the parent for whatever reason can't have these kids return home to them, that there is a relative that's been identified that can be the forever home for this child, so that we can maintain those familial connections and those familial relationships. Sometimes appropriate family members just don't exist for whatever reason, or they choose to not be involved for whatever reason. And so the concurrent plan might be unrelated adoption. So there's a variety of things that could be the concurrent plan, but almost always exclusively, with very, very few exceptions, the primary plan is certainly going to be family reunification. I would say, the rare exception might be something like, some case of child sexual abuse in the home by the parent caregiver. In that situation, probably, the plan is not going to be to return that child that's been victimized to that home. But short of something like that, the expectation is going to be that we're going to work with that family to reunify. Just to give you some basic understanding of how investigations and alternative response works. Again, and you guys may recognize this from last year's session on 101, an intake comes in, so an allegation of abuse or neglect comes in, and it can come in either via telephone call to statewide intake or email or fax. But regardless of the method of the allegation coming in, we get an allegation, it gets routed to the appropriate region and county. A caseworker gets assigned that case, and they go out and they make an assessment of that allegation. So if the allegation is, for example, parents were initially involved in a verbal altercation that ultimately turned physical, mom was holding an infant trying to leave the home, and then dad, either forcibly pushed mom or shoved mom or struck mom in some fashion, and that jarring, may have pushed her up against the wall and it knocked the child that she was holding out of her hands or up against the wall, and the child was injured in some way, then obviously we would investigate that, and then we would what's called disposition that. So we would either have one of four dispositions. The two most common ones are either going to be ruled out or reason to believe. Ruled out meaning that what was alleged in the intake didn't occur, or it didn't occur the way that it was described in the intake. So it didn't meet the criteria for abuse or neglect, or that it was found reason to believe, which means that the allegation did occur and abuse or neglect did in fact occur. And so that's pretty black and white. Either didn't occur, ruled out, it did occur, it met the definition of Texas Family Code, abuse and neglect, found reason to believe. Separate from that, we have two other dispositions that are to a less extent used. The first being unable to complete. We rarely use that, or we try to use that not very often. Unable to complete simply means that we started to investigate a case, but for whatever reason, we were unable to complete that investigation. Most often that happens when the family moves and they can no longer be located. So they might move out of state and we can't track them down, or they might move within state, but they're successfully avoiding CPS. And so we do a variety of things to locate families when they do move. We have staff with special access that can do searches on a variety of mediums. They can look on social media, they can look through benefit records to see where a family's benefits are being sent to. We can look potentially at school records, et cetera, et cetera. And sometimes we're able to find those families and continue to work with them. We might have to have that case reassigned to another caseworker in another region. And sometimes we can't find them. And if we can't find them, like I say, it's closed as unable to complete, or UTC, which leaves an alert in the system. So if the family does have a subsequent case later on, it is automatically escalated to our highest level of concern. It's automatically treated as a P1, which P1 means that it needs, P1 stands for priority one, meaning that it needs to have immediate contact within 24 hours. So any case that we close UTC automatically defaults to that kind of urgent level of assessment, just because we weren't able to completely assess them last time. So we want to make sure that things haven't escalated and gotten worse. And then the last disposition, again, not used as often as ruled out or reason to believe, but that's unable to determine. UTD, unable to determine, is exactly as it sounds. It means that we obtained as much information as possible, but we were unable to determine if abuse or neglect occurred. So going back to the example that I gave earlier, that might be something like an allegation that a really young child, a 5 or 6 year old child, was seen meandering, the block in the neighborhood unsupervised for 20 or 30 minutes, and we can't, we're unable to make contact with the person who made that allegation, so we can't confirm how exactly they come to the conclusion that it was 20 or 30 minutes and not 3 or 4 minutes. We speak with a parent, they give us a completely different version of events, and we're kind of left with, was it 4 minutes? Was it 20 minutes? It's unknown. The child, wasn't harmed. So we might provide some supports. We might provide some child locks for the house. We might provide some education and some supports, but ultimately we can't confirm one way or the other all the facts in the allegation. So in a situation like that, it might be just closed, unable to determine. So hopefully all that makes sense. But it's just an example of how differently all these cases are kind of treated. So moving on to the next kind of topic here, I really want to spend some time to talk about terminology, because terminology for us is something that makes a really huge difference. And I think for you all in the audience, potentially as stakeholders, or agencies who collaborate with CPS, you hear these terms all of the time, and they don't necessarily mean to us what it might mean to you or what it might mean to the family. And so that lack of understanding or that kind of misunderstanding really creates a lot of confusion. I oftentimes get calls, as do my peers, get calls about cases involving, let's say, a mother being discharged from a hospital. She's just delivered a child. Maybe mother and or child were positive at the time of delivery for some controlled substance, and some action was taken. And kind of the default language that seems to always be used is like the child was removed from the parent, and almost without fail, there might be some advocate from the hospital or birthing center or from a treatment provider or whatever, with questions about what justified the removal, and so either myself or one of my peers might get involved in these cases, and we'll start investigating the facts of the case to try to figure out, like, well, how did we get to this point, only to find out that there isn't a removal. And so it's just a misunderstanding of the language and what things mean. So I hope to clarify that. So we'll start with the removal. So from a legal perspective, removal simply means for us that a parent's rights to provide, those parenting tasks has been temporarily legally removed. Those responsibilities have been removed from that parent, and they've been given to us as an agency. So when we use the word removal, we're speaking from a very legal context. That means that we have assessed the situation. We have filed a formal affidavit and a court report to the court. The court has reviewed it, which means either a district attorney or a county attorney or a regional attorney has reviewed it on our behalf. They've verified that it meets whatever legal criteria is required. It's been presented to a judge. Again, the judge, being a completely neutral party to this case, will review the facts contained within the affidavit. they agree that at least temporarily, this situation is unsafe, and that relief is granted. That relief being that we've sought removal and we've been granted removal. And so now we have temporary custody, and we either have to place the child with an appropriate relative or in a licensed foster home. And then we'll start working that case from a conservatorship standpoint to try to reunify the child back with the parent. So that's how we view removal. Now, that's not how the rest of the world views removal. Oftentimes, anytime a child is not with their parent, the word removal is used. And so like if mom discharges, or if the baby discharges separate from mom and they're not going home together, everyone will say, well, why was the child removed from mom? Mom will have questions about why the child was removed. The family may have questions about why the child was removed. A social worker at the hospital may ask us why the child was removed, or an advocate for mom, somebody in treatment, anybody who's made contact with that family may view that as a removal, even though for us that's not a removal, because there wasn't a legal mechanism. We would only call it a removal if we took those steps. There are all kinds of other scenarios in which a mother and child may be temporarily separated short of legal intervention. And we'll talk about those in a moment, but those could be something like a parental child safety placement, which is often referred to as a PCSP. And that's a voluntary agreement that has no legal binding. There's nothing filed in court, but that's just an agreement between a parent or caregiver and the department that this situation is currently temporarily unsafe in some way. So for the short term, and PCSPs are intended to be very short-term solutions. So it's almost Band-Aid like, I guess, if you want to think about it in those terms, but it's a very short-term solution. And so we would do a parental child safety placement to address a very short-term situation until some longer-term resolution can be achieved. So a parental child safety placement might be something done in lieu of a removal to prevent the department from filing a formal legal case. So the parent in that situation may recognize, I don't want to have court involvement. I don't want to get legal involvement. I don't want this potentially to drag out a year, but I do recognize that today my home is not safe for whatever reason. So they will agree to do a parental child safety placements. There might also be scenarios where before CPS ever even gets involved, the family has privately kind of intervened. So there's certainly examples of this that occur all the time, where we have, let's say, a mother with a substance use disorder, and the family has been advocating, trying to get mom to help. She's been reluctant to get help, or very slow to get help. Mom delivers, and the family shows up at the hospital and says, hey, listen, when CPS shows up here, and they will show up here, this is going to turn into a legal case. This is going to turn into a removal. This is going to be a court issue. And so they may have a completely separate conversation without DFPS and privately agree that grandma's going to take the baby home or whatever. And so, and then when we show up, a couple hours later, there's already been some arrangement agreed upon that we really weren't a part of. But the end result kind of is very similar to something we would have done. It just happens that it was done without us. And so we wouldn't call that a parental child safety placement because we didn't facilitate that, but we might call that a safety plan, meaning that, like, hey, the family agreed on this safety plan. We're just going to put it on paper that, like, this is the plan that they have independently agreed to, but we didn't initiate it. Again, to an outsider, the end result is the same, right? Mom and baby are not together. So to an outsider, that very often is just viewed as a removal. but there is some nuances and context to that. So that's what I just want to make sure that everybody's kind of aware of. Again, I touched on this a minute ago, but I'll just mention it again. PCSPs, parental child safety placements, are completely voluntary. They have no legal standing. So a parent can end it kind of whenever they want. They can agree that for the next 30 days, their child is going to be with a supportive aunt and uncle. And then 2 weeks into this agreement, they can decide, you know what, I no longer agree, and they can end that placement. There's nothing formally that would prevent them from doing that. You know, the aunt and uncle can't call law enforcement and say, well, I have a parent-child safety placement that says for the next 30 days of agree. There's no legal standing there. There's nothing that can be done. The caregivers who have the child are provided with some very basic paperwork that would allow them to, you know, get the, you know, it's basically like a power of attorney type document that would allow them to get the child to a follow-up medical appointment, or if the child is school age, to just ensure that they can, you know, keep the child enrolled in school, or enroll the child in a different school, or make arrangements for the child to go on a bus, or, you know, go to daycare, whatever. I mean, it's some very rudimentary, basic kind of permissions that are granted, and all that's provided to both the temporary caregiver, as well as a copy is provided to the parent. So they both kind of know, like, this is what's been agreed to. We've kind of facilitated this agreement. And so then we have a copy. So the department has a copy of what the two parties agreed to. The parent has a copy saying, like, okay, we've agreed to do this for the next 30 days or the next 45 days. And then we're going to revisit the situation. And then the parental child safety placement family will have a copy, so that they can do those basic tasks. You know, I think as long as there's open and honest conversations about what that looks like in the beginning, parental child safety placements certainly have the potential to be a really good tool for families, because one, it keeps them out of the court system, which is oftentimes something that they prefer to just not get involved in. Obviously, once you get something involved legally, you're adding more and more parties. You're adding parties that are going to advocate for you. So I mean, I think the parents do need to be aware of that as well. They're generally speaking going to be appointed an attorney, so they will have an advocate for themselves, but the child will also have be appointed an attorney, and the child's needs may be contrary to what the parent needs at that particular time. So the child's attorney may advocate that the child is not safe to return home. The child may be appointed a CASA, which is a court-appointed special advocate. The child is going to maintain a caseworker. So it gets a lot of parties involved, and so sometimes you know, legal court cases are exactly what's needed, and sometimes legal cases can be overly burdensome and complex. So I think every case, you have to look at it on its own as an individual situation, based on exactly how safe or unsafe a situation is, and determine if a parental child safety placement might or may not be appropriate in that situation. But I think, again, if the family is is being educated by the caseworker, and all of these things are being carefully explained, then ultimately it's up to that parent to make a decision that's best for them, and ultimately a decision that actually works for this relative, right? You also don't want to burden this family member, or put them, kind of back them into the corner, you know, in the middle of the night, as in the middle of some emergency, and have a grandparent agree to a PCSP or parental child safety placement, when in reality, they're in no place to really do these things. They're in no, you know, maybe they have their own issues in terms of, you know, they lack resources, or they lack reliable transportation, or, you know, maybe they're just too old to take care of an infant, or whatever it might be. And just out of a wanting and a willingness to help this family member, they'll agree to this PCSP only to then, in 24 or 48 hours, come to realize that, like, I'm in over my head. So we certainly want to avoid those situations. And the way to do that is for our staff to really have those really careful, thought out conversations and make sure that everybody's on the same page, understanding what the responsibilities are, so that they can make the best decision for them and minimize the number of moves that any child might make. We want, if the child is going to be moved out of a parent's home for one reason or another, we want those number of moves to be as minimal as possible. So if the child is going to go from mom and dad's house to the grandparents' house, it's ideally with the expectation that they're going to go from grandma and granddad's house back to mom and dad's house, not that they're going to go from grandma and granddad's house to aunt and uncle's house, to then another aunt's house, to then a nephew's house, and then back to mom. We want to limit those moves because it just, like trying to limit trauma, trying to limit, all of those things. And so we have to be careful with how we deploy a parental child safety placement. And then lastly, again, talking about safety plans. Safety plans are created by an individual, and they address a very specific set of concerns. They have really, really limited timeframes. So a PCSP, I think, can be extended up to 90 days. A safety plan really has a 30-day or less limit. It is super, super short. Very much like a safety plan. It is, like a parental child safety placement. It is also not legally binding. It is just a voluntary agreement, and it is designed to address a very specific concern. So you, as a CPS staff, we can't write a safety plan that just lists this like wish list of everything that we want them to do and everything we don't want them to do. That's not the purpose of a safety plan. A safety plan really is to address a very specific issue. If, let's say, the issue involves domestic violence and you've got one parent who's the aggressor, the safety plan might be that the aggressor leave the home for the next 2 weeks until we can come together and have some kind of a family team meeting and come up with some longer term solution. So we might ask that aggressive parent to stay with a friend or relative and kind of have a cooling off period while we all kind of come up with a much longer term plan. So in that situation, that break might be the only thing that's in the safety plan. We're not going to have that break and then a whole host of services that we want them to do as part of that safety plan. That's really not, that wouldn't make a very good safety plan. Same thing if it involves substance use. We might have a safety plan that literally just asks that caregiver abstain from using a substance and call OSAR and make an appointment to have an assessment, and that might be the extent of that safety plan. And then we would reconvene after they've had their drug and alcohol screening assessment, and then come up with a longer term plan based on whether there's going to be some treatment intervention, whether it's going to be outpatient, inpatient, whatever it might be. But once we know those facts, then we would come up with some longer term plan. So safety plans, again, like PCSPs, are voluntary, but they're very, very short term, and they're meant to address a very specific thing. So then lastly, I want to touch base on how to work with families. And there's a lot of ways that we work with families as an agency. There's a lot of ways that you all as stakeholders work with families. Obviously, if you're in the hospital systems, you provide direct care to these families with both children and parents. If you're in the treatment community, you're providing direct care to these families who have substance use disorders. If you're in the education field, et cetera, et cetera. Everybody interfaces with these families in a slightly different way, but ultimately for the same goal, which is to provide, support for these families to make them kind of a better, more complete version of themselves. And so I think we all have the same ultimate end goal, but our vantage point and how we're going to achieve that is slightly different. And so in thinking of ways in which we can all work together collaboratively, I think it's really important that we look at ways where we can all share our expertise and what it is that we know, both good and bad, about a family, to make as informed decisions as possible. So with that, I'll give you a couple of examples of things that we can do to work with families. The first is a family team meeting. Family team meetings generally occur within the context of an investigation or alternative response case. They can occur in any stage of service, but generally that's where they occur. Family team meetings are relatively short. I use the term relatively, obviously, kind of loosely. They tend to be an hour and a half. That's not super short, but it's shorter than the next option. They're parent driven, so there is no preconceived CPS agenda of like, we're here to talk about X, Y, and Z. We have some ideas, but ultimately this is parent driven. The idea behind a family team meeting, and then subsequently we'll see the concept is the same with the family group conference, but it is meant for the parent to identify what they can do to address the situation at hand. There is a neutral facilitator assigned to a family team meeting. So if I go to your home and I'm your caseworker and I have some concerns and you have some apprehensions about what our intervention is looking like, I may pose to you that, hey, are you interested in a family team meeting? Which would be an opportunity for you to kind of get all your supports together, come to the table, and let's discuss this and let's figure out a way to address these concerns that I have in front of me. If you're the parent and you agree, then we work with this neutral third-party facilitator to set this up. And so this third-party facilitator would then would facilitate the meeting, keep us all on task. They would actually take notes, and they would list down like what CPS is responsible for, what the parent is responsible for, any caregiver that comes to the table and says they're willing to provide some kind of assistance is responsible for, any provider who's at the table, et cetera, et cetera. So everybody leaves there with kind of a very detailed roadmap of how to best help this family. So as an example, using a substance use case as an example, let's say that we have a mother who delivers a child, and mother and or child or both are positive for methamphetamines at delivery. The child is going to be in the hospital for 2 or 3 days. Mom discharges 2 days prior to the child. So the child is kind of very temporarily safe for the next 2 days because they have 2 days before they discharge. But mom is out of the hospital. So in that day or two that mom is out of the hospital, we may try to set up a family team meeting. The parent is allowed to invite whoever they want. So the idea is they can invite safe and supportive support systems, right? So if they have aunts, uncles, grandparents, nephews, nieces, people from their faith-based community, friends and employers, co-workers, neighbors, if they're involved with a Mommy and Me program, and they have an advocate through them, that advocate is certainly welcome to come. It's whoever the parent invites. CPS is not the one making those invitations. So it's really client driven. It's very parent driven. They invite who they feel like they want this information shared with, because what's going to occur in that meeting is some very personal information is going to be shared that would otherwise not be shared. I'm sure you guys have all been in situations before where you've seen firsthand that CPS goes out and is particularly in the investigation phase. You've got investigators who are going out and gathering information. They may be speaking to hospital staff about a positive drug test or positive prenatal records or whatever. And so we're gathering all this information, but you've noticed that we don't share any information back to you as a provider. So we gather all this information, and you may or may not think there's a concern, or you may think that there's a plausible explanation, or you think that mom may have had, you know, a previous substance use problem, but now let's say she started to engage in treatment. And so you feel like, okay, well, mom has begun the steps to kind of mitigate this situation. And so you're kind of confused as to why CPS is maybe pursuing this in a way that you feel is I don't know, maybe overly aggressive, or you know, like a bit more intense than you believe it might need to be. But that might be simply because we've gathered all this additional information that you're just not privy to. You know, we've checked criminal records. We've checked we've checked our own previous CPS history. So it might be that, unbeknownst to you, this is the mother's fourth CPS case. It might be that, unbeknownst to you, dad of this newborn just got out of prison 3 weeks ago for manufacture of a controlled substance because, you know, he had a meth lab. You know, it could be that, you know, we do law enforcement call outs, and, you know, we're notified by law enforcement that the house is actually under surveillance because of suspected drug sales out of that home. So we might have this whole other separate set of concerns that has nothing to do with the childbirth directly. So the positive childbirth is simply another concern, but separate from that concern, we might have 4 or 5 other concerns, and we're just unable to, you know, like, to just share those openly with an advocate or provider, because we don't have a release to share that information. And so I understand that it can be kind of frustrating because, again, we're taking in and gathering all this information, but very little, if any, gets shared back your way. So again, going back to these family team meetings, this is the forum where all of that information is openly shared. So that's one of the very first things that happens is that once a family team meeting occurs, the facilitator will lay out the ground rules for the meeting. And they're very basic ground rules. Obviously, be respectful, kind of talk, you know, one at a time, silence cell phones, you know, all of the typical rules that you would expect of a formally facilitated meeting. There's nothing out of the ordinary. And then the one thing that is made clear is that, like, some very confidential information is going to be shared. The parents are agreeing that that information is being shared with the individuals that have been invited to the meeting. So if the parents have invited these individuals to the meeting, then they are privy to this information. If they weren't invited to the meeting, then that information is not to be shared with people outside of the people in this meeting. So if you were fortunate enough to be invited, then you're kind of in this circle of trust. And so within this circle of trust, you might be hearing for the first time that dad just got out of prison 3.5 weeks ago. You might be hearing for the first time that there's concerns about possible drug sales out of this home. You might be hearing for the first time that this is the 4th DFPS case, and that we've tried, you know, less invasive interventions in the past. Maybe we closed 2 cases in the investigation stage. Maybe we closed 1 FBSS case, and yet we're here for a 4th time. So we might be looking at it from the standpoint of, we might be at a point now where we might have to take temporary legal custody because nothing else seems to have worked. And if you weren't a member of, if you weren't a party to some of this information, that might look to you like an overreach, but once you see the totality of the information, that may make more sense. So that's why I think sometimes participating in the family team meeting is important for providers, just so that they can get a full picture of what's happening. It's also important for providers because you might be that parent's only advocate. And so you might be that parent's person. You might be that parent's person to say, like, yeah, despite this history, these bad things that this parent has been involved with in the past, this is what mom has done really well in the last 45 days that we've been working together, in the last 62 days that we've been working together. You know, Mom has started outpatient treatment. Mom has got a plan to do a parenting class. Dad has engaged in this program. The probation, his probation officer may actually say, hey, dad has actually been compliant since his release. I don't have any concerns. So it's important for really two main reasons that providers, whenever possible, again, assuming that they're invited, attend these meetings, even if it's telephonically or even if it's virtually. And that is, one, so they can get the totality of information, and two, so they can advocate on behalf of the parent when they have something positive to say, because we need that complete picture. The intent of a family meeting isn't just to kind of quote unquote dump on a parent and fill the air with a bunch of just negative information about all of our concerns. All of our concerns are going to be aired out, but we also want to hear about all the good things. So we need that grandparent to say, well, like, she's really struggled, but she's come a long way. We need that advocate to say, mom has actively reached out to try to get into outpatient treatment, not because she is trying to avoid CPS, but simply because she is trying to get some recovery in her life. She's trying to be a safe and sober parent for this child. So that's why it's important. Again, I mentioned this earlier, they're most often done in the investigation stage. They can occur virtually or in person. Obviously, during this past 14 or 15 months during the pandemic, most of them occurred virtually. Moving forward, I think there will be a mix of them being virtually and in person. It's really up to the family and the caregivers and the providers as to what everybody feels like is safe, and also what they can commit to. It might be that if you're the hospital social worker, or if you're a mommy's and me provider, or if you're a treatment provider, it might not be possible for you to take off 3 hours of your day to go drive to this family team meeting and then drive back. But it might be that you can log on for 45 minutes. So I think we're going to maintain that flexibility moving forward. The next, here's an example of family team meeting. So just concerns about a family related to child safety. And so we're going to discuss things like, what is a sustainable plan for the family? Again, it's not what we want it to be. It's not this pie in the sky plan. It's what the family can actually do. That's why it's parent driven. So again, if we have a parent with a substance use disorder, the plan isn't CPS telling mom, hey, you need to go to the Betty Ford clinic, or something outrageous like that. Like, you need to spend $40,000. I realize that you are in the low income population and you're currently unemployed, but that's not my problem. You need to spend X amount of dollars to go to treatment. Obviously, that is not the intent. The intent is for the parent to articulate to us however they can, in whatever way that they can, what they're going to do, what they're willing to do, what they're capable of doing to keeping this child safe. That could be, I'm going to go do an OSAR assessment. I'm going to see what state funded treatment options are available for me. And then it's working with the other attendees to figure out a plan to help mom and dad really activate this plan. So if the plan is mom is going to go to OSAR, but mom doesn't have a car, then the plan might be to identify, okay, well, what relative has the time and the bandwidth, to take an hour and a half out of their day to drive mom to the local mental health authority so that mom can get this drug and alcohol assessment, or who has a good relationship with mom. So if mom is or if dad is struggling with their sobriety this week and they had a bad day at work and they're thinking about using, and they've got 9 days of sobriety under their belt, but they got yelled at, or they got to work late because their car broke down or whatever, and they want to return to those old coping mechanisms. Who can they call within this small group to kind of talk them through that? So there might be some uncle, or there might be some cousin, that they've got a really good relationship with, that might step up to the plate and say, you know what, if you're really struggling with your sobriety this week, or anytime in the next 6 months, or anytime in the next year, or anytime ever, call me 24/7, 365 days a year. I'm your person. You can call me. So the idea behind these plans is to lay out all of those things. We're going to talk about supports. We're going to talk about transportation. If we need to identify someone or groups to help with finances, if that means identifying local community resources or food banks or whatever, then that's what the goal is to get all of our heads together and come up with plans that will eliminate those barriers, so that the plan that's created is actually actionable, and it's actually doable, and it's not just some plan that's doomed to fail. So again, I don't want to go through all of these verbatim, but I mean, you can see kind of how this stuff works. Family team meeting is held to identify family members might be considered for placement. Mother's discharging from the hospital tomorrow, which is very similar to the example I gave just a few minutes ago. I should say medical providers. I apologize, just see a typo there. Medical providers discuss the needs of the mother and the infant. There's older children in the home, so we have to come up with a plan for those kids. Mom is talking about, her willingness to engage in services, and then we come up with a plan for, mom's visitation for this newborn that's in the NICU until the newborn is discharged. And that plan might be like, not only the actual plan of like, okay, mom's going to come every day during visiting hours, but that plan may also include, well, how's mom going to get there? How's mom going to get back? What mom is expected to bring? All of those things. So the plan is very, very thoroughly laid out. And again, the idea being that all of the people participating in this family team meeting are active participants and providing like guidance and support to mom as she's saying these things. And so if there's something that's not doable, they need to really step up and say, like, I would love to help you, but I'm unable to take off Monday, Wednesday, and Friday from 2 to 5 to do this. So I can't be that person. And then somebody else might step up and say, well, I'll be that person. Or the case worker may take one day, and an aunt and an uncle may take one day, and a grandparent may, we'll kind of hodgepodge it together as long as there's a plan. But that's really the goal. And then here's another plan. Again, this is this example involves a mother and father using marijuana recreationally. We've got an investigation called in about the parents' ability to provide safe care. This is very typical of cases that we get literally every day in CPS. In terms of our substance use cases, the bulk of our cases involve marijuana use. If I had to rank them in order of like the types of drugs that we see, by a mile, marijuana is predominantly the cases that we get called in at, followed by stimulants, primarily methamphetamine, methamphetamine to a lesser extent cocaine, opiates, kind of below that. The cases we get called in the least about, I would say, is probably going to be something like alcohol, some synthetic drugs, psychedelics, LSD, psilocybin mushrooms, things of that nature. Or rarely do we get calls. We do get calls about those, but very rarely. Marijuana is predominantly what we get called about, and again, stimulants, predominantly methamphetamine. So this example is very typical of a case that might actually come in. So we have an FTM to discuss with the parents and the family why CPS would actually be concerned about our parents' marijuana use. Again, this is a very typical situation. We often find ourselves in a room with parents all the time who will say, well, what's the problem? It's legal in California. It's legal in the state of Washington. It's legal in Oklahoma. Like, none of these other states have a problem. Like, why does Texas have a problem? What I would remind individuals is that, like, we're not a law enforcement agency. So whether something is legal or illegal really does not play a role in our decision making or why we may or may not do something. We are a child safety services agency. So if someone's use of something impairs their ability to parent safely, that's why we become concerned. And so whether marijuana is legal or illegal in Oklahoma or California or Washington State or wherever really is of no importance to us. It's whether or not your use is impacting your ability to parent safely. And if it's been determined that a situation has become unsafe, then it's our job to work with the family to address that situation so that we can put some safeguards in place so that parents can be safe. Ideally, we would want them to do that by discontinuing marijuana use or any other use of whatever substance is making them unsafe. But if they're unwilling or to cease that use, then we certainly will, the next best thing is to make sure that the family's immediate support system is aware of our concerns and that they're going to somehow self-regulate and put those safeguards in place in lieu of CPS, So that means that there could be a grandparent or aunt and uncle or a neighbor, whoever is identified those are going to be the individuals to make sure that if, mom and dad choose to use marijuana, let's say in this example, that for the next 2 or 3 hours, the kids are playing with the next door neighbors and not potentially in danger, or their grandma and granddad's house or whatever. Again, our primary goal with all of this is to make sure that the kids are safe. It's not to police the parents and what they do, or to be concerned about whether what they do is legal or illegal. That the legality of something, that's a law enforcement issue. That's not a CPS issue. We're dealing with, is it a child safety issue? So again, in this FTM, we would talk to the parents about our concerns. We would have a conversation about when the use occurs and making sure that there's sober individual present. We would establish some kind of a plan, basically indicating like, if dad is going to use, then maybe mom is going to be the sober caregiver, or vice versa. If mom is using, dad is going to be the sober caregiver, or we're going to identify a safe and protective neighbor next door, or a family member, or whatever it might be. But that's really the goal in all of these things, is to come up with these plans. And the only way to do that is to have these meetings and to have open and honest conversations. Because if we don't do that, then if we don't do that, then we're the ones coming up with all of this on our own. So it's certainly much better to empower the parents to come up with their own plan that's actually actionable. As a caseworker, I don't know anything about your next door neighbor. I don't know if your grandma and granddad are protective. I don't know if you have a good relationship with your aunt and uncle. But if you invite all of these people and they step up to the plate and they agree to be these protective individuals, then that's your call to make. We're just here to facilitate those conversations. So then shifting over to family group conferences, it's basically the same type of thing. It's just, they just happen to occur in conservatorship cases or in family-based safety services cases. So you do a family group conference in a case that's already been open for a while, whereas you do a family team meeting in a more emergency type situation in the very beginning of a case, in an investigation, trying to put safeguards in place so that potentially the case doesn't have to progress. Whereas a family group conference, the case is generally already progressed, but you're coming back together to talk about progress in the case. They're not as time restricted, so family group conference may last a few hours. I mean, it's not uncommon for a family group conference to go 4.5 hours, particularly if the case has been open for 6 or 7 months and parents have had a variety of providers. Let's say that mom and dad have both gone to treatment. Let's say, they've both had a variety of therapy modalities. Let's say, somebody was involved in an anger management class or a batterers intervention class. They had done parenting. There's a bunch of family members that want to provide, context about the growth that they've seen the parents have in the last 6 or 7 months. All of those things would add to how long that family team meeting or family group conference, excuse me, can last. That may mean that meeting can last 4.5 hours. Doesn't mean that every participant needs to be there for that entire time. So again, if you are an advocate, you may pop in for, virtually for, 30 minutes at some predetermined time, or you may come in and out and leave. But it just means that the meeting itself is going to last longer. The other difference between a family team meeting and a family group conference is that a family group conference is scheduled pretty far in advance. So they're able, because there's not nearly the sense of urgency as there is with a family team meeting, they're able to set this out a couple of weeks in advance. They're able to work with all the providers and all the family members to really get everybody's schedule kind of lined up and figure out a day kind of out in the future that might work for everyone. I should also point out, and this goes for both family team meetings and family group conferences, it is not at all uncommon for these things to be done after hours. So these things do not have to occur between 8 and 5. I have myself participated in hundreds of meetings, from 6 to 8, from 5:30 to 7:30, 5:30 to 8, like that. We try to do these things around the parents and the family's work schedules, or whatever may be going on. So there is no hard and fast rule. A family team meeting tends to be more urgent because it's the beginning stages of the case, and you're trying to avoid the case from stage progressing. So there's a little bit of urgency. We're trying to get that done, set up in the next 24 hours, 48 hours. Again, with a family group conference, not nearly the same level of urgency. We still want to get this meeting done, but we're already actively involved, and we've been involved for likely a few months, so we can be a little bit more sensitive to everybody's needs and work a little bit more to ensure that we have as many participants as possible. Like a family team meeting, a family group conference is also parent driven. So again, it's up to the family to invite whatever supports they want. It's also facilitated by a neutral facilitator who's not a decision maker. They simply are taking notes, and they're simply kind of facilitating, okay, mom, what's your opinion? CPS, what's your opinion? Provider A, what's your opinion? Grandmother, what's your opinion? Et cetera, et cetera. They're moderating the meeting. They're not making any decisions. They're not placing any blame or judgment. And again, just like the family team meeting, it allows for an open forum for information to be shared that otherwise would not be shared. You would otherwise likely not have any idea about mom or dad's, criminal history, or mom and dad's, CPS history, or if you're a substance use treatment provider, you may have no idea about mom and dad's domestic violence history. Or if you're the domestic violence, advocate, you may have no idea about mom and dad's substance use history, or you may not have any idea about some mental health history that was diagnosed 7 years ago, but parents have stopped, treating it and have started self-medicating with substance use instead of through their local mental health authority. So there may be some old diagnosis out there that might need to be readdressed. So again, the beauty of these meetings is that you get everybody at the table. You get to learn the totality of the information, not just your little piece of it. And then ultimately, we can all better advocate for these families based on everybody's information, not just our perception or our limited understanding or our vantage point. I think I've already talked about this. They happen FBSS and conservatorship, FBSS family-based safety services and conservatorship. And then lastly, here's an example of what a family group conference might actually look like. Mother and father in this scenario have an open family-based safety services case. It's been open for 3.5 months. The original case came in involving substance use and some other problems coping with stress. The investigation, was concluded within 45 days and stage progressed to family-based safety services. Family-based then, connected the family to the appropriate providers. And so now at the 3.5-month mark, we're kind of reconvening to discuss the status of the case. What progress has been made? How are the parents thus far in treatment? Have they completed their treatment? Are they near completion? Were there any recommendations for aftercare? We'd want to talk to the parents about what kind of tools they've added to their toolkit about how to cope with stress. Are they engaged in therapy? Was therapy recommended? Is there any trauma that they're dealing with? Have they been able to mend some maybe broken or mismanaged relationships with family members? Are they in a better place today now than they were maybe 3.5 months ago, 4 months ago? So it allows us kind of a sneak peek after this intervention to kind of see where are they at now, so that now at the 3.5-month mark, are they in a place where we can have really good, honest conversations and feel good about like, okay, well, let's get this case closed in the next 30 days. Okay, you guys are in treatment, or you guys have completed treatment. You're in a good place with your family. You've kind of worked through some things through therapy. We've got you connected with a resource that's able to continue to offer you therapy even after CPS closes their case. Maybe this treatment or this therapy or whatever is going to be paid for through, Medicaid or through some community resource that you have access to outside of CPS. So let's talk about a plan. Let's get this case ready for case closure. What do you need from us? Do you need us to set up daycare? We can. There are, in certain situations, we're able to kind of do a one-time like protective daycare payment to kind of pre-authorize a certain amount of daycare in advance as a case closes, so that your family stabilizes. Is that what we're looking at? Or is this case not ready to close? And if it's not ready to close, then let's not just tell the family it's not ready to close, but let's tell them specifically why it's not ready to close. What exactly is left, so that it's not vague, so that it's not some kind of some unknown. Let's be very clear as to what's still needed and who can help assist with what. And again, family, friends, advocates, all of those people play a crucial role in helping a family in that situation, both whether a case is going to close or whether a case still needs to close. Either way, all of those supports are absolutely critical to help that family get to that next stage. If they're going to close, you're going to want all those supports in place to ensure that like this case closure doesn't become a new stressor. If it's not going to close, we want to make sure that learning that it's not yet ready to close doesn't in and of itself become a new stressor. So it's really important that, again, all these supports are in place. And so again, I go back to what I was saying earlier. This is a great way for all of us, whether it's providers, whether it's family, whether it's CPS, whether it's, treatment, whatever. These meetings are great places, not only to learn about exactly why we're involved, exactly what the concerns are, but also how we can all help, what you have personally seen. And so with that, I kind of leave you, I want to leave some time for questions, but, obviously some takeaways. The three main takeaways are obviously that we have 3 stages of service. And so you can kind of generally understand where this case likely is just by understanding who you're speaking with. When you're talking to a caseworker, just ask them, like, what stage of service are you in? If you're talking to an investigator, then you're likely talking to someone about something that's just very recently happened, or something that you yourself or someone within your staff may have directly called in, right? So, use those context clues. So if you're at the hospital and you're speaking to an investigator and mom or the baby were positive at delivery, then that investigator is likely there because a call was made. If you're in that same situation, but you're talking to conservatorship, then that should be a clue that, like, in addition to this positive, this family already has an open case, because there's no way a conservatorship worker would be there unless there was already an open case. So understanding the stages of service should be a clue to you as to like just how far involved this family is with CPS. The second takeaway should be that context matters. Words that sometimes seem simple, something like removal is actually quite complex. You know, when I say removal, again, I'm talking about the legal standing definition. That means that DFPS has legal temporary custody of this child. There's an affidavit somewhere. There are court orders somewhere. When I hear someone else tell me like that a child was removed, I have to kind of extrapolate, well, what does that actually mean to that individual? Are they using that same terminology of removal, or are they just simply saying mom and child aren't together, therefore they're removed from each other? I totally understand that logic, but it's just not the same thing. And then finally, providing information to you guys about progress is really important. And the way to do that, or the way to receive that information, since we don't just have releases on hand for everyone, is to encourage you all to participate in family team meetings and family group conferences. Even if you're advocating for mom and you have a release from mom, for us to disclose our concerns about, you know, mom's issues, we don't have that release, or you wouldn't have that release as it relates to any dad's issues. So if we have concerning information about dad, I still wouldn't be able to share that with you, or vice versa, you know, whoever it is that you're advocating for or working with. So there's just things that limit us from being able to express exactly, you know, what all our concerns are. So hopefully all that makes sense. I think we're about to open it up for questions. I will say that if you have questions in the future, you can feel free to email me directly at marco.quesada@dfps.texas.gov. And then we also have a generic mailbox. There's 5 of us that are substance use program specialists. Myself and Karen Palumbo are here at state office in Austin. And then there are 3 scattered throughout Texas. You've got Alex Murillo in the Dallas area, Sherelle Gibbs in the San Antonio area, and Nancy Villarreal in the Houston area. But all 5 of us have access to the substance abuse specialist mailbox. So you're certainly welcome to send any kind of general questions to that generic mailbox, and we'll be more than happy to answer them. Or you can email me directly. You know, the goal is not to make things harder for you guys. So whatever we need to do on our end to facilitate a conversation, or to connect you to the right caseworker, or to answer a question, if you're working with a mom and mom is confused about something, and you know, we're here to help. So with that, Sharice, I'm open for whatever questions have popped up.
Okay, we have about 5 in the queue, so let me go ahead and get started. The first question is, can you give an example of an instance where FBSS would be court mandated?
Sure. So I think you guys are fortunate that if you're going to participate in tomorrow's training, one of the facilitators is Judge Martinez Jones, and she is the judge over the Travis County Drug Court. All of those cases are actually court-ordered family-based safety services cases. So that's one example. It might be that it's part of a specialty court program. So the reason why in that scenario they're court-ordered is because we recognize that recovery and sobriety is not on a Texas Family Code timeline. So there's no guarantee that within a year, someone with a really severe substance use disorder may reach recovery and be able to demonstrate that. And so the model that Travis County uses is that they're still legal cases, but they use the family-based safety services court-ordered model, so that there's no timeline, so that if it takes a parent 14, 15, 16 months to recover, they're not facing potential parental child right termination because they've exceeded that 12 months. So that's one scenario. Another scenario just might simply be that we've tried a voluntary family-based case, but the parents has just have simply been slow to initiating services or have been unsuccessfully discharged from one service or another. And we've sought relief from the court. Maybe CPS has sought temporary managing conservatorship, and the judges reviewed it and said, I don't think you meet the burden for the state to take temporary custody. However, I do recognize that you're trying to voluntarily work with this family, and they're not engaged, or they're not as engaged as they should be. So instead of giving you custody, what I'm going to do is I'm going to order the things that they have already voluntarily agreed to do, but now there's an order. So now I'm going to enforce those things. So now it's not I'm just going to agree to go to treatment, or I'm going to agree to do therapy, but now they've been ordered to do. And so now there's a expectation that, like, okay, you've got 30 days to engage in this or that. And so those are some two basic examples of how that may happen.
The next question is, working on a methadone clinic, I have heard many times that caseworkers sometimes discourage clients from participating in medication-assisted treatment or do not support this treatment approach. What is the perspective of the Department of Family and Protective Services regarding that?
That's an excellent question. And I would say that I believe probably all my peers are watching this as well, and they would all agree with me. I can tell you that there's nothing in our policy that discourages MAT. We do MAT trainings all the time. Alex Murillo is actually in Region 3 in the Dallas area. He and Karen are collaborating to do a whole series of, they have an annual MAT training in that area, and they're in the process of doing that, I believe either later this month or at the beginning, or I guess the beginning of next month at some point. So we have ongoing MAT trainings for staff statewide, and we oftentimes get involved in situations exactly like the one that you're discussing, where if you work for a medically assisted treatment provider of any type, whether it's a methadone clinic, or if you are, a provider who's, prescribing Suboxone or something, and you feel that a caseworker is discouraging the use of that, please contact us. You can either contact me directly, or you can contact the substance abuse specialist mailbox. But please reach out to us so that we can figure out what exactly is going on. I will tell you that we research, those statements when they occur, and it's not always what it seems, and I'm sure that's not shocking to anyone. There are some times where the caseworker has incorrectly discouraged the use of that, and so we definitely correct that situation, and we staff it up, and we make sure that their entire chain of command, their leadership, not just the caseworker, but also the supervisor, also the program director. I mean, we have a very thorough call to make sure everybody's on the same page, that those are medical recommendations, and we cannot go against the medical recommendation. But we oftentimes also run into situations where, we reach out to the caseworker and we find out that that's not the issue at all, that we aren't the ones discouraging the use. And what's happening is the parent is saying, I want to get off methadone, but this provider is insisting that I need to be on methadone for the next 3 years. And and I keep advocating for myself, I want to be off in the next 30 days or in the next 60 days. And they're telling me no. And so there are times where there, I guess, a parent or a patient, depending on the situation, is kind of playing the agencies against each other in one way or another. So they might be telling you that CPS is asking them to get off. They might be telling us that they don't want to be on, but you're forcing them to be on. And so again, we investigate all those situations and try to get down to the bottom and try to figure out what's going on. And that might be another scenario where a family team meeting or some kind of informal meeting might be hugely important, just to get everybody on the same page so that everybody's getting the same information, and so that we're not kind of being played against each other. So hopefully that makes sense. But please absolutely reach out to us.
Okay, the next question is, when a child is legally removed, court ordered, is it at the request of CPS, or does a judge make that decision solely based on the information he has received?
Well, I guess it's a combination of both. So we can only remove with a court order. So it is ultimately ordered by the court. A judge is the one that, like CPS does not just go somewhere and remove a child independently of a court order. It is via a court order that's been reviewed and signed off by a judge. So a judge independent of CPS is the authority that grants CPS the removal. However, the information that the judge received is based on the findings of the investigation of CPS. So otherwise, the judge wouldn't have any of this information otherwise. So the way it works is, again, we get an allegation of abuse or neglect. The investigator goes out, gathers the information. That might be information from a hospital, that might be information from a provider, a neighbor, law enforcement, whoever it is that called it in. We get as much information as possible. We make the determination that the child is either safe or unsafe, and then we staff it internally to see if in the situations where the child is unsafe, we usually will work with the attorneys that represent CPS to say, okay, well, if the child is unsafe, could the child potentially be safe with a relative? Is there someone that we could do a parental child safety placement with or a safety plan with that would mitigate this concern? And if that exists, we have to go the least restrictive route, unless the parent is just like, they're not willing to do a PCSP, they're not willing to do a safe, like they're, and so if our hand is forced and we have to request custody, then we write the affidavit. So I think to answer your question, the judge is the one that grants us custody, but it's based on information that's provided to them by CPS.
Okay, thank you. Next question. Can safety plans be extended? Are there alternatives if a participant does not follow safety plan guidelines?
That's a great question. So again, safety plans are intended to be very short term, 30 days or less. If, at the end of 30 days, you're reviewing the case and, you're meeting with the family and there's some reason to extend a safety plan, there's nothing in policy that would prohibit you from like initiating a second 30-day safety plan, for example. So you could just start another one once that first one lapses. I think you would need to look at that very carefully on a case-by-case basis to determine why you would need a second or a third safety plan. I think if you got to the place, I think a second safety plan there might certainly be situations where that's warranted. I think if you're 3 months into a case and you're doing a third safety plan, I think you really need at that point to really reassess the situation and say, okay, well, this really should be a family-based safety services case. This might need to be a PCSP. There need to be something a little bit more structured instead of these like very, very, very short-term solutions that have to be extended. Again, there's nothing in policy preventing it. I think you would have to look at it on a case-by-case basis, but absolutely you could do a second safety plan for sure. If we got to 3 or 4, I would probably question that.
The last question in the queue is, are FTM and FGC done for all families? And you may want to say what those acronyms are.
So FTM, Family Team Meeting, FGC, Family Group Conferences. Great question. They are not done for all families. They are offered to all families. But because they are parent-driven and parent-initiated, a parent has to agree to have a family team meeting or a family group conference. It's also their right to decline. So there are certainly scenarios in which a family may decline, either because one, they don't want their friends, family, and support systems to be made aware of these other concerns, because like I say, that's really the only forum in which we're allowed to openly share this otherwise extremely sensitive information to these other people. And so they may simply just not want that information shared, or they may just not have a strong support network, just that they themselves may be children of abuse and neglect. And this may be a very cyclical thing. And so like there may not be an appropriate grandparent or aunt and uncle. And so sadly, there just may not be support systems. I can tell you that I am a huge believer in family team meetings and family group conferences. I did them all the time when I was in the field. I believe in them wholeheartedly. I cannot recommend them enough. Selfishly, just because I think it's a lot of stress to be a caseworker and have, kind of all the child safety kind of rest on your shoulders. And so if I could kind of spread that responsibility and have a family group conference or family team meeting and make everyone aware of the concerns and kind of make sure that everybody has equal concerns, then I want everyone to be as aware as I am. And so I did them all the time, but again, it comes down to whether a parent wants to have one or not. And it's, a parent is asked, and it's ultimately up to them if they choose to do one or not. And if you're working with a parent and you feel like they haven't been asked, then absolutely encourage them to speak with their caseworker about a family group conference or a family team meeting.
Okay, well, that was the last question. And I want to really thank you for joining us today and providing all this important information to bring awareness and provide solutions for neonatal abstinence syndrome and in recognition of NAS month. We really appreciate you so much, Marco.
Well, thank you guys. Y'all have a great afternoon.
Have a good one. Bye.
Bye-bye.